So we'll just give it a couple minutes to let people trickle in, and then we'll get started.
Okay. Yeah. I mean, you have sort of a pretty good system. You've had just really great people.
Oh, thank you. I appreciate you saying that.
No, I don't know why I saw the list the other day, but I mean, really, I think just an impressive array of knowledge that you've been providing, which is nice.
Yeah, everybody's been so generous with their time, and it's been a really neat series. We're excited about it.
Oh, good.
Yeah. All right. Let's go ahead and get started. I want to welcome everybody to the University of New Mexico Law and Mental Health Didactic Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're glad to have you all here joining us today. My name is Julie Bravko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. So don't forget that next week we have UNM's very own Dr. Heath Hodges, who is presenting Rethinking Supervision in Forensic Psychology. For our talk today, please ask your questions in the Q&A, not the chat box. Anytime you feel comfortable, just know we're not going to get to them until the end. I will try my best to get to as many of your questions as possible, but please forgive me ahead of time if I can't get to yours. For those of you who want CEs but are on a tight schedule, you do have to stay for the full hour. You don't have to stay longer than that. But we may be staying on a little bit longer to answer questions. For those of you that are here for CMEs, the medical CEs, you want to go to the chat now. There's a sign in there. For those of you that want the mental health CEs, we're going to do that at the last 5 minutes of the talk today. So we'll post a link to a survey. You're going to fill that out. Make sure you save a copy of it, print it, do whatever you need to. We don't keep copies and we don't email copies out. So that is your responsibility. The recording link and the PowerPoint will be uploaded in probably about a week. So give us about a week. And if you don't see it on there, then start reaching out. Now it's time for what we've all been waiting for. I'm going to introduce to you our speaker for today, Dr. Jodi Quas. Dr. Quas is a professor of psychological science at the University of California, Irvine. She is recognized across the globe for her work on children's eyewitness capabilities, memory, and suggestibility, and the consequences of exposure to family violence and legal involvement on children and adolescents. She's dedicated not only to pursuing rigorous science on crucial topics relevant to identifying and intervening on behalf of violence-exposed youth, but also to disseminating findings to diverse audiences. Dr. Quas, thank you so much for being willing to present at this series. I am honored to welcome you, and I want you to know that we're so grateful for your time and expertise today. I'm now going to turn it over to you.
Well, thank you very much. I'm actually delighted to be here. This is a great opportunity to, I think, both talk about some work that I and others have been doing, but also get some interesting feedback and questions and suggestions. So with that, what I usually do on most of my talks is I begin with just a little bit of an overview of my own expertise, mostly so that people don't have very high expectations. But my training is, I'm actually a developmental psychologist by training. I also have done a postdoc in public health and developmental psychobiology. So I have kind of a broad range of training. Note that there's no clinical training in my background. So I am not a clinical psychologist. Most of my work focuses on children's and adolescents' involvement in the legal system, particularly with respect to eyewitness capabilities, but also in terms of how to engage children and adolescents in conversations about trauma, about abuse, and ways of enhancing their disclosures to improve their participation in legal settings. Because of this research expertise, I do a lot of training for on these topics. I do training for educators, physicians, psychiatrists, attorneys, social workers, et cetera, really focused on how to assess children's eyewitness capabilities, how to prepare children and families for courts, and more broadly, how to talk with children and adolescents about trauma and violence, including violence that they may be exposed to in their communities or in the media. But what I'm going to focus on today is, I think, one part of this and a narrower part of this, and I'm going to focus on sort of this immersion in the legal system, both in terms of how much children and adolescents understand the legal process, and then also how involved or how engaged they are and how well they participate. I kind of have two parts to this presentation today. I'm going to talk first about what youth actually understand about the justice system. I actually have parents as well, because youth aren't the only participants in many facets of the justice system. And I want to talk a little bit about parents. Then I'm going to transition and I'm going to talk about not just what they understand, but how we can improve that understanding. And in doing so, how we can kind of better engage the different participants in the justice system when they have an ongoing case. So I want to sort of explain to you what I'm thinking about when I talk about the justice system. I am using kind of the California kind of guidelines. When I say juvenile justice system, I'm actually talking about the two branches. Some states actually classify these differently, but in California and in many other places, the juvenile justice system really has this delinquency and dependency branch. And so when I use the term juvenile justice, I'm really thinking about both branches, both when youth are considered to be suspects or offenders and they may have committed crime, but also when families become involved in the justice system because they may have been exposed to or witnessed violence in the home and children's safety is at issue. Both of these branches are really guided by rehabilitation, best interest of the child, but there are some important differences. I did find, for those of you who focus more on one system or another, I did find this 2018 handbook that was actually put together by the University of New Mexico School of Law that really does a great job of sort of kind of really outlining some of the procedures and details of the New Mexico system. So wanted to put that up there as well for everyone. So I'm going to kind of go back and forth between these two branches of the juvenile justice system when I talk about engagement and understanding. So kind of first, though, turning to this understanding of the system is actually a really important part of participation. We expect participants in our justice system, children and adults alike, to understand what's happening, even at a basic level. That understanding is designed to sort of facilitate their ability to sort of comprehend what's being told to them, to understand their own requirements. That understanding is designed to ensure that they are communicating effectively to the appropriate people, that they understand the decisions made, and that they feel like their voices are heard. But what we don't know a lot about is how much they actually do understand. And so let me first kind of talk a little bit about children. So these are dependency-involved children, children who have been exposed to substantiated maltreatment and potentially removed from home because of that maltreatment. They may be living with non-kin foster parents or in foster group homes, and they may, in all states, they do have representation, whether it's an attorney or a guardian ad litem. And so these dependency-involved youth are supposed to or believed to understand at least some of the parts of their experiences. And so what I want to talk about is whether or not they actually do. And findings right now suggest no, they don't adequately understand. I'm going to show you just one sample piece of data of this to kind of demonstrate really some of the limitations in their knowledge. I am a scientist, so I always have to kind of back up what I say with data. So I'm going to be doing that throughout today. In one of our projects, we actually recruited and interviewed children and adolescents who are currently living in out-of-home care. These children and adolescents actually attend some of their dependency hearings. This is in LA County. That's an LA County model. If you have questions at the end, I'm happy to talk about the model it sounds kind of overwhelming to children. It actually, I'm fairly supportive of it now that I've seen it, but children regularly attend their hearings. And so we were able to interview them before and afterward about their understanding, both in general of the dependency system, but also their understanding of their own case. So we actually tried to tap into their understanding in a couple of different ways. Don't make fun of our very low-tech drawings, but we did give them some stories, and we would read parts of stories, and then we would ask them questions about this. For those of you who do forensic work, we actually modeled our questions after something called the MCATCA, which is a competency assessment for adults. So we had kind of series of vignettes that we would sort of follow through and ask kids questions about it the whole time. We also asked them to define terms that are commonly used in the dependency system, including really simple terms like minor, foster parents, kin, etc. Then what we did is we also, after their hearing, we actually went into their hearing with them. Then afterward, we interviewed them very briefly, just, well, what happened? What happened in the hearing? These were usually kind of 6-month review hearings. A few of them were these early kind of detention hearings where they were deciding initial placement. But some of them were actually kind of these long-term placement hearings where final placement decisions were being made. And then we asked children where they would live after that hearing, which is a really important issue to children involved in the dependency system. Just to kind of give you an example of the way that we would code some of these definitional questions, when we asked them about a social worker, we would score them as 0 is not anything. They provided no correct information. 1 would be some correct information, and a 2 would be we think they really actually do understand what the role of this particular individual is in these definitions. And so these are just 3 examples of different ways we would code these types of data, with higher scores indicating greater kind of understanding of, in this case, the social workers. So when we looked across our measures, just how much do children know? What we found, what this shows you is their definitional knowledge on the left and their storybook knowledge on the right. This is just how correct they were. In the definitions, the most they could get was 2. In the storybook, the most they could get was 4. 2 things you see here. One is unsurprising, knowledge or understanding really does increase with age. Nothing surprising there. We should all know that. Anyone who works with children knows that they do get better. In addition, though, even though our terms were fairly simple, our storybook was really designed to provide a lot of scaffolding. What you can see is even at the oldest ages, knowledge was really moderate at best. So children don't have a basic understanding of just some of the key terms that they hear all the time, nor can they really track particularly well what's happening and who's making decisions in a sample case as described through a storybook. I want to show you one more piece of information, because I think we have this habit of thinking, well, if children have been involved for a while, they know. So, we might spend more time on the children who have recently been removed, but not on the children, or more often adolescents, who have been in the system a long time. When we actually compared understanding to children whose cases have been going on less than 1 year, 1 to 3 and 4, what you see here is basically length of time in the system doesn't matter. In our particular study, nor was length of time related to their age. So it wasn't like the older kids were in the system the longest. Instead, what you see is that over time, children aren't actually abstracting and learning more. And so I think that's a really important kind of message to kind of keep in mind, that even children who've been involved in the system for some time don't adequately understand it. When we looked at their understanding of the actual hearing, so they went in, they sat in their hearing, they talked to the judge, they had an attorney, we actually see in one way, children actually do pretty well. When you ask them, who are you going to go home with after today? Most of the children, or majority of the children in our sample, know. So when it comes down to kind of this very simple issue, there is some evidence of knowledge. Children actually know in that hearing, based on that hearing, who they're going home with. On the other hand, if you look across and you say, okay, well, did they actually track anything else in the hearing? This is where you get more variable understanding again. And so some of the children, if you ask what the judge decided, they just couldn't say anything. So they couldn't articulate or explain what had happened. Some children would be partially correct but incomplete, and about a little under 20% actually understood. So for example, sometimes children would correctly say, oh, I can't go home yet. So they had an understanding that the decision was not made to let them go back to their parent, but then they might not say, they're like, oh, well, they're just going to wait a little bit and then they're going to let me go home. When in fact, the parent had to complete a number of different tasks or activities or requirements in order for that child to go home. When we looked at kind of the kids who were providing no correct information, we had a few situations where children, they were in termination hearings or long-term placement hearings, and the children would explicitly say, I think I'm going home. I'm going home next. So they really weren't tracking the bigger picture issues that were being discussed in these hearings. Now, some people asked, does that mean that children shouldn't attend their hearings? Again, I don't think that having children not attend hearings will improve their understanding. Children do want to be involved. They want to know what's happening. The cases dramatically affect their lives. And so by not exposing them to any information, we're also really limiting their knowledge or understanding of these hearings in which they may or may not participate, but these hearings that dramatically and significantly affect their lives, both in the short and long term. So there's an interesting thing with this, because I talked a lot about children's understanding of the dependency system. And several years ago, when I was presenting to attorneys in California, one of them made this casual comment noting that, children are the only ones involved in dependency cases. And so we kind of stepped back and we thought about this, and they kind of, they made this comment that, we think children don't understand. Well, do parents even understand? And parents are also in dependency cases. Parents are actually their own parties. Each parent has his or her own representation. So it's not just like the delinquency side where parents are there to support children. Parents actually have their own representation, and they are participants in dependency cases. And the requirements on parents in dependency cases are enormous. So once children have been removed from home and placed into foster care, there are a number of crucial requirements placed on parents for parents to have their children returned. So parents have to attend all their court hearings. Parents have to participate in mandated services. These might be about substance use, domestic violence, or parenting behavior, anger management. So you'll see all sorts of services that are required of parents. Parents are also required to attend visitations. Most of the time, these are supervised. They might be in specific locations where they can be supervised, but parents are required to do that. And finally, parents are required to maintain stable housing and work. And so when you start to look at these requirements of parents and you think about the demands placed on parents, two things I think are really important. One I'm going to talk about today, any lack of understanding on the part of parents about any of these requirements can affect parents' behavior, which in turn can affect the court's decision about whether or not the parent is meeting the requirements. So if the parents don't fully understand when or how to schedule services, the parent won't schedule those services, and that can then be used against the parent. In addition, and what I'm not talking about today, but what we're actually looking at now is just the incredible burden that all these competing requirements place on parents. That in a way, if parents have to attend hearings, participate in services, and attend visitations while maintaining work, that's almost an impossible task when you think of just trying to schedule work, get out of work, catch buses to make hearings, you sort of wonder how parents can manage all these things at all. So I kind of wanted to keep those things in mind when we schedule, when we think about the role that parents play and the demands that we place on parents. But for today's purposes, when I talk about what I want to just mention very briefly is whether parents, dependency involved parents, understand the process. So I'm going to show you when we first started talking about this issue, we had a few attorneys that kind of understood why we were pursuing this work, but other attorneys in the courts themselves actually said, don't worry, we give parents a chart. And so I love this chart. This chart's from Florida, by the way, not that the charts in any other states are any less complicated. But I look at this thing and I think, you give this to parents? Oh, well, that's it. Then great. I'm sure parents totally understand, because they understand like disposition hearing, shelter hearing, judicial review. Those are all common terms. So you look at this, and if parents have their children removed and they're handed this form, you kind of wonder, you have to step back and think, okay, is this really that helpful? You've got admit, consent, deny. So by giving parents this form, there is an underlying assumption that, oh, now parents understand the system and they can kind of follow along and do what they have to do. Well, what we did is we wanted to test those types of assumptions. And so we recruited parents in California and Florida. They were racially and ethnically diverse. They were different in the two locations just based on the demographics of the two locations. And what we did is we actually did a pretty similar type of interview with them, where we questioned them about their legal understanding. We gave them some definitions, and then we did the same type of idea of a vignette following kind of the McCatco or the MacArthur competency assessment to kind of see, do they understand, can they track a case, and talk about the different players. Very briefly, just let me show you now that the terms that we asked parents were kind of the terms that parents would see in these hearings that they're required to attend. Knowledge at best was mediocre. When we looked at their definitions and their vignettes, out of a max of 2, you see that they basically kind of had this kind of mid-range of a 1. So really, parents don't adequately understand. They're sort of getting some information right, but they're really missing out on a lot. When we looked at what types of characteristics predicted lower understanding, a lot of these are really as you might expect. So parents who were younger tended to have more difficulty. They had exhibited poor understanding. Fathers, more so than mothers, had poor understanding. Black parents, as opposed to parents of other race and ethnicities, tended to have more difficulty in their understanding. And finally, as you might expect, lower educated parents had more difficulty understanding. So taken together, what this suggests is that we focus a lot on children and children's understanding, but given the significance of parents' involvement and the need for parents to adequately understand their case, we really aren't doing parents justice here by making sure, by failing to make sure that they understand this process. And if they don't understand that process, that can directly affect their behavior and hence their ability to have their child be reunited with them. So I just have a couple of examples of quotes from some of the parents, that really, I think, highlight both this lack of knowledge, but also really the challenges of sort of juggling everything. Parents don't know who the different players are and what their roles are, so they might not understand the different roles of their attorney versus the social worker. They kind of group everyone together, judge, social worker, everyone, again, failing to discriminate among the different professionals with whom they might interact. I have no idea what's going on, and they talk at each other and they don't talk to me. So really you see signs both of this lack of understanding, also this sort of inability to deal with the competing demands, and really the sort of the feeling of disengagement in this process. So I want to flip gears for just a moment and talk about the delinquency side. In the delinquency side, youth are afforded many more due process rights that are more similar to criminal defendants in criminal cases. And so when we look at understanding and involvement in the dependency side, we might see lower, but what we should expect to see then is higher in the delinquency branch. So what I want to do is I want to talk about legal understanding in juvenile defendants, specifically in relation to one particular type of hearing. But first, I do want to show you that they also give juvenile defendants a chart. So here again, if a juvenile enters the juvenile justice system, they give them a chart to kind of help them navigate. And I'm certainly not advocating for failing to give them anything. I think they should be given information, but I think these charts are really complicated, and I'm not entirely sure that these types of charts are really that beneficial in terms of actually understanding the process and then understanding what's happening and what decisions are being made. The specific hearing I want to talk about, though, is the plea hearing. Similar to in criminal court, most delinquency cases and in juveniles taking a plea, or in states like California, it's not legally called a plea, it's called admitting guilt. This is a vast majority of the cases, but the consequences of doing so are really significant. If you take a plea, they typically go on probation. There are restrictions that are placed on them with friends and school, travel, which can affect sometimes whether they can pick up siblings or not. There also can be loss of benefits. So sometimes FAFSA, funding opportunities for community college, for university, can sometimes be affected if youth plea, particularly in certain states. There can be a loss of driving privileges. Again, if you think of sort of families kind of juggling needs of multiple children, when youth plead guilty, they can lose their driving privileges. There's also kind of this potential for deportation if they're not citizens. So there are enormous consequences to even youth pleading guilty in a case. Now, the courts recognize these consequences, and so they actually have set up this requirement for pleas to be accepted. They must be done so validly. So pleas must be made voluntarily, intelligently, and knowingly. These components, voluntary, intelligent, and knowing, are assessed by the juvenile court judge in the hearing in which a juvenile admits guilt or pleas. Now, what we were interested in is, gosh, these are really kind of serious consequences. Do youth even understand when they accept a plea, what that means? And so we were really interested in these components of a plea. So we had the opportunity to interview youth defendants about the plea. These are all youth who had pled guilty recently within the past few weeks. We recruited them from their first probation meeting post-plea. 74% were male, a majority was Latinx, which is consistent with the location where we recruited. The youth all were aged 14 to 18. So there was really this adolescent age. About half of them had prior contact with the justice system. So again, you can sort of think of this, if they have prior contact, maybe they know more. I just want to give you a couple sample items of how we were assessing this. They were semi-structured interviews. I'm just going to show you a snapshot of some of this. We actually asked them yes, no questions. I understood the requirements. So this is not asking them what those requirements are, a point to which I'm going to turn to in a moment. This is really just asking them, do they think they understood? Or do they think they understand? We then, though, did assess what we're calling their actual understanding. And here, when you think of their actual understanding, we actually gave them items and we asked if they were true or false, and we then would code their accuracy. If I look at the data, I think the data are really telling. So when we looked at just their perceived understanding, do they think they understand? The answer is, for the most part, yes. When we looked at, do you understand the plea? Do you understand the consequences of the plea? If you just ask kids if they understand, they will say yes. Any parent knows this, any clinician knows this. If you ask kids yes, no questions, they just sort of nod to get you to stop talking, especially adolescents. But when we looked at their actual understanding, how accurate were they? You see this drop to below chance levels. So you think they understand, but they don't. Moreover, when we looked at these two together, the more they said they think they understand, the less they actually did. So this is really, I think, important in terms of how are we assessing understanding in youth, both in the delinquency side, but possibly in the dependency side. And do they think they understand, or are we really assessing how much they actually understand? Because at least in adolescent age youth, these may be going in opposite directions. So given this, what I want to do now is I'm actually going to flip to the second part of my talk. Given that knowledge or understanding is low, given that perceived knowledge is high, what I want to do is I want to turn and I want to talk about, well, what are we going to do about this? What can we do to enhance understanding? And then in doing so, maybe enhance engagement so that we are collecting information from participants in an effective way. We're ascertaining what they do and do not understand so that we can make sure we're addressing those gaps in their understanding to facilitate their participation. So kind of bottom line is number one, involve everyone. So make sure that children are involved, make sure that adolescents are involved in both the dependency and the delinquency side, and make sure parents are involved. They're all key participants and they all need to be fully informed and engaged in order for justice to be served. In addition, though, I'm going to go back to kind of my other, years and years of training and expertise. It's also crucial to use best practice questioning approaches, both to assess knowledge and to encourage engagement. So often when we think of best practice questioning, we focus exclusively on eyewitness reporting, on memory and suggestibility. But what I want to stress today is that the same strategies that are best practice in interviewing contexts are actually best practices across the board to assess knowledge and understanding. So I'm going to kind of go through and give you just a couple of different examples of this, again, spanning the dependency and the delinquency side. So first, what I want to do is I want to give you an example from placement decisions. So when children have experienced substantiated maltreatment, they're removed and they're placed into out-of-home care. There's a number of kind of factors that will go into how social worker, judges, and kind of with attorneys' input make decisions about placement. They'll take children's needs into account. They may try to take into account placement of siblings. Can we keep siblings together if that's possible? Is there the availability of kin care? We know that children do better psychologically and kind of behaviorally and even academically when they're placed with kin. What about schools? What schools are available? Can we keep them in their same school? Are they proximal? Are they close to the family members, the caregivers from whom they've been removed that may facilitate visitation? So all of these factors are taken into account. What varies substantially across counties, but even more so across states, is whether youth's own kind of preferences are also kind of weighed in those placement decisions. And it continues to be debated about whether or not youth should be asked about their placements. You see this same debate kind of being played out sometimes in custody and kind of family law cases, where there's debates about whether children or adolescents should be asked about their placement preferences. On the one hand, by asking children to provide input or asking youth to provide input, you are obtaining information, unique information that you may not otherwise know about. In addition, it provides some level of empowerment to youth. Their voices matter, their opinions matter. That empowerment can actually be beneficial. Kind of on the other hand, there are concerns that there is an emotional burden that is really placed on youth when you ask them with whom they want to live. That requirement of making these types of decisions may just be too distressing for children. There's also a really heavy emphasis on the idea that children will only tell you what they want. They don't have the capacity to kind of weigh their best interests. So in the case of removal from home, that children in essence will just want to go back to their parent. That's what they know, that's the parent they love, even if the parent may be maltreating. And so there's the debate about whether children actually have the capacity to report on their best interest. So we've been doing some interesting studies on this very issue, and what we've really focused on is whether and how well children of different ages can answer these questions about placement, and also what types of questions are best. So in one of our studies, we asked children, where would you like to stay if you could live anywhere? This open-ended question that doesn't kind of force children into, a yes or no answer. In another study, we looked at, do you want your current placement, whatever that was, to be permanent, or if you could live with anyone, who would it be with? And you notice in that study too, there's a really different kinds of questions that we're asking of kids. One is specific to their current placement, and one is more open-ended, asking them where they want to live. So when we looked at our first study, just with whom 4 to 11-year-olds want to live, and we just look at the percent who wanted to return home. What you see here is this is a percent who wanted to. And so a couple of things. One is that if you average across these two, you actually see that less than 50% or maybe 45% want to return home. So children don't universally just want to go back to their biological parent. Children actually have some capacity to kind of weigh these different placement options. What you also see, which is not surprising, is that kin matter. Consistent with all the science that suggests that children do better when they're placed with kin, children also seem to recognize that. So you see significantly fewer children say, I want to go back to my biological parent when they're placed with kin than without. So kind of take home message, children, even young children, 4 to 11-year-olds, don't universally just want to go back to their biological parent. And second, kin matter. We have other data showing that particularly for younger children, sibling placement also weighs heavily into that. So these family relationships are really important. When we looked at our second study, the findings are a little more interesting because they highlight the importance of question type. So what this shows you is when we asked them this yes/no question, and we said, do you want where you live now, whether it was with kin or not kin, do you want that place to be permanent? What you see is you see a little over half the children saying yes, slightly more with kin, as you might expect, but even without kin, you see a lot of children saying, yes, I want this place to be permanent. In addition, and I just have this comment on top, when they were asked, do you like your current placement, you have 90% saying yes. So again, this yes/no question, you see these high percentages of yes answers. So they like their placement. It looks like they want to be kind of stay there and they want it to be permanent. But when you asked them with whom they wanted to live, you asked them these open-ended questions, you see these numbers drop. So when you say, do you want this place to be permanent? You see higher percentages of yes. When you actually ask them, well, if you could live with anybody you want until you're grown, who do you want that to be? You see these percentages of kids who want to stay in their current placement drop. With kin, it drops to under 40%. Without kin, it drops to under 30%. So question type, how you ask the question, dictates the answer you'll get. So kind of bottom line, across age, when people talk about this idea of placement decisions, youth can provide reasonable preferences about placement. They prefer family over non-family, but they don't only want to go back to their biological parents. Even relatively young children have some ability to gauge. And so asking them about their placement preferences may be a useful way of gathering more information and empowering them. Even if their preferences aren't kind of followed, they at least feel like they have a voice. In addition, though, how the questions are asked is really crucial to eliciting accurate information. The yes/no questions, where children's options are limited, you get more limited information. By opening up the question type, you get far more information that may be more useful to the decisions being made. So kind of finally, I want to go back to this idea of juvenile defendants in plea. So I'm kind of going back and forth here. And as I mentioned, when juveniles plead guilty or admit guilt, they have to do so voluntarily, intelligently, and knowingly. These are specific requirements that our justice system imposes on all defendants in delinquency and in criminal court. And the gatekeeper, the person who determines whether the juvenile plea is valid, is the judge. So the judge has to, in these hearings, really weigh and assess whether these three components of plea validity have been met in order to accept the juvenile's plea. Well, how do judges do this? And so we actually had this incredibly unique opportunity to observe juvenile plea hearings in California and Virginia. The reason it's unique is that in these two particular states, these hearings are closed. And so normally these hearings are not open to the public, but we worked very closely with the courts in these systems, and we were able to observe a large number of these. Most of the defendants were male. We weren't able to collect any information on who they were, but in California, whenever we could, the data are very consistent with what we've seen in the counties where we were doing the study. California, we had a 76% Latinx. Virginia had a kind of different demographics. Just to give you sort of a snapshot, we actually had coders in the courtroom that were sitting and just listening, and they would just document what was happening. So whether the juvenile received a written copy of the plea, so did they receive kind of a written version of what happened? Were they named on the indictment? Was the form read? Was it signed? The judge might ask, did they understand the charges? Did they understand the plea form? Did they have any questions? So we would just check off very quickly what was happening in these hearings. And we also just kind of as a little bit more information, we actually timed these hearings and kind of just to see how long they were lasting. They usually last about 6 to 7 minutes. I think a couple of them would last longer, but most of them are about 6 to 7 minutes in length. From the checklist, I'm just going to talk a little bit today about a couple of different items. We did try to capture something about their participation, the juvenile's participation or engagement. We coded whether they asked a question in the hearing, whether they answered at least one of the questions with something more than just a yes or no or head nod. Did they actually elaborate, or when they were asked a question, did they just nod or say yes or no? When we looked at plea validity, the three components, there were multiple items on this checklist that were really kind of tapping into these, the knowing, intelligent, and voluntary. So we would code whether the judge asked, do you understand the charges? Whether the judge asked if the juvenile understood the consequences of pleading guilty, whether the youth made a free and voluntary decision. So this slide has a lot of information on it, but I'm going to kind of talk you through. So when you look at the three components of the plea validity, knowing, intelligent, and voluntary. There were a maximum on your right of 15, 20, and 4 items that could be checked. What you can see, and I'm sort of less interested in the comparison between California and Virginia because they were just one county each, but the differences are striking where you see these, but even in California where it's substantially more, at best, they're covering less than half of these components of the plea. You see knowing, out of 15, California was 6, Virginia's really not covering very many at all. Intelligent, out of 20, you have 8, little under half, and same thing, voluntary, between 0 and 1. So what you see here is, even though juveniles are pleading guilty, even though the judges are really, trying to track this, you see that they're not tracking this in a comprehensive way in either county. When you looked at engagement, we actually had coded for whether the youth asked a question across, these several hundred hearings we observed. Not one youth asked a question independently, so we couldn't code for that. And when I'm talking about asking a question, this is in the hearing. The youth might have talked to an attorney beforehand, and certainly I think that's what judges are assuming and hoping. But we weren't observing kind of the pre-hearing conversations. We were observing the actual hearing. When we looked, most of the youth just provided simple answers to the judges. In a few cases, less than 20%, did the youth elaborate at all when the judge posed a question to them. So to kind of summarize this, first of all, judges really varied quite a bit in their assessment. But the most common strategy were these do you know questions. And if you sort of go back to what I've been kind of harping on, this idea of perceived knowledge, the idea of asking these yes/no questions where you get these very limited answers. Asking youth, do you know or do you understand? You may get a lot of yes responses, but that probably doesn't tell you whether they actually understand. We did not see in any situation where the judge provided any elaborate explanation to youth or asked youth to explain any of the concepts. And so you don't see this assessment of sort of what youth actually understand. Instead, it's just kind of checking off, do you understand? And really, and finally, youth are at best really minimally engaged in this. They may not fully understand, even if they think they do, and their engagement in this hearing that is crucially important for their future looks to be minimal at best. So to kind of summarize, question type matters. It wasn't kind of it's a hidden kind of really crucial point of this talk. So number one, avoid yes/no questions. Like, did you sign the plea voluntarily? Do you like where you live? Do you understand what's in your case plan? Regardless of the participant, yes/no questions may not give you a full picture of what someone actually understands about this process of justice involvement. Instead, ask open-ended questions. Tell me what voluntary signing the plea means. Where do you want to live until you are grown? Describe what's in your case plan. By asking these open-ended questions, you're going to get a much more comprehensive answer, and you're going to be able to really gauge what the legal participants know and what they don't, so that you can target kind of information and kind of education appropriately. So to kind of turn back to the two beginning questions, what do youth and parents understand about the justice system? Understanding is really limited at best, especially among lower income individuals and regardless of time in system. I think that's a really important issue to remember, that just because someone's had prior contact, just because their case has been ongoing, doesn't mean they understand and can navigate what are incredibly complex, and difficult processes. And second, how can we improve understanding and engagement in the legal system? Number one, involve all participants, not just children, not just adolescents, involve parents as well. ask open-ended questions to find out what they actually know, and then explain everything, even to those who claim, especially via these yes/no questions, that they already know. So in closing, kind of, before I wrap it up, in case we have some questions, I just want us to kind of stress, giving everyone a voice in the system in which they're immersed and helping them understand their rights, their case, and their options will not only ensure that they feel heard, but it really will ensure that justice is pursued and that justice is fair for everyone. And so with that, I think I'm going to open it up to questions. I feel like I've given this hour-long monologue here, but I'm going to open up to questions. But if you have questions, I also put my email on the bottom of this. You are absolutely welcome to reach out to me with further questions. If you need any of the sites or the articles, feel free to kind of do that as well. I am happy to provide you with information. If I don't respond, please email me again. We're in the end of the quarter, and so emails kind of are flying in right now. So if I don't respond, please again, just sort of follow up with me.
Thank you so much for this really important and informative talk. We definitely have questions. Have there been any assessments of competency evaluations to see how well they measure this lack of knowledge and how effective restoration is in increasing this knowledge?
So the short answer is no, not in dependency. In dependency, it really seems like it's its own entity and beast that hasn't received the type of knowledge and attention that other areas. So kind of this idea of restorative kind of competency or kind of legal knowledge is something you see much more often in criminal, a little bit in juvenile, kind of delinquency side, but we've never seen it in dependency. It's not something, given legal rights, that people have really thought about. I think that would be incredible and important. We've just not seen it at all in dependency, at least in the states with I'm familiar.
Next question is, you were talking about kin, and this is a clarification question. What does with kin mean when parents are kin?
Oh, sorry. Thank you. That's a very good question. So who are kin? When children have been removed from their biological parents because of some form of maltreatment, placement with kin is placement with a biological relative who is not a biological parent. So it's usually grandparents, aunts, uncles, and the like. Sometimes it's a cousin or an older sibling, but it's someone who's biologically related to a child who's not the biological parent.
Do you have a citation for the observational study of plea hearings?
I do. It's in press. You'll have to send it to me. It's in press. Dr. Allison Redlick, who is at George Mason University, is the lead author on it.
Is the goal of increasing youth's understanding to only facilitate their comprehension with decision-making, or does this also change the likelihood of accepting plea deals that may be detrimental to them in the long run?
So I think that's a good question. I think there's several reasons why youth need to understand the plea. One is they need to understand what they're agreeing to. They also, so if they're going to agree to a plea, they need to understand what that means for them and their future. And they can be detrimental. Sometimes they might not be. Sometimes they might be negotiable. But I think you want children, just like adults, to understand, even at a basic level, what they're agreeing to do. And so I think it's not just to sort of enhance their understanding of the process, it's really they're putting their name on something that is directly affecting their future. And so for that reason, it's crucial that they understand.
And if it comes to light that a juvenile does not truly understand the legal decision that they make, are there any corrective actions that can be done post hoc?
So if there are attorneys on this. I would love their input. I'm not an attorney, and certainly in criminal court, if a defendant believes that a plea was done incorrectly or not kind of legally sound, the defendant can appeal a decision. And I've not seen them in juvenile court, but that doesn't mean they cannot appeal. The challenge with juvenile court, unlike criminal court, or I guess both branches, but is juvenile plea hearings aren't open to the public. And so there aren't the same record keeping documentation and details that there are in criminal court. So in criminal court, there's a court reporter who records everything. And in delinquency, particularly if it's not one of the formal hearings, you may not have that same level of documentation, which is really that's really when you appeal a plea, you need that documentation in order to show why or how the plea was not taken in a valid way.
So presumably the role of the attorney for parents and kids in dependency cases and for kids in delinquency cases is to assure that their clients understand in a meaningful way what's happening and the consequences of decisions made by them and about them. Can you comment on why children with attorneys are so compromised in their understanding? For example, is it a result of the developmental limitations on cognitive capacities like abstraction, alternative futures, or are attorneys just often lax or bad at communicating with clients?
So I would not say attorneys are lax or bad. That would not be. What I do think is that attorneys, number one, I think attorneys in both dependency and possibly delinquency are really overworked. So one is, I think they're overworked. They don't have a lot of time. Different states also operate differently. So in some states, it's the guardian ad litems who are representing children, and they may or may not be trained in how to provide developmentally appropriate language to children about a case. And so if you have attorneys who are not trained in how to talk to a 6-year-old about the justice system, for example, the attorney may be attempting to provide information. And so it may be that there's a mismatch between what the attorney knows on how to talk to children and the children's developmental level. So it's not a cognitive, it is a cognitive capacity limitation in children, but it's also one that can be overcome if you have individuals kind of working with children who understand that, but also who have time. And I think, part of this challenge is a time challenge. Attorneys, you hear kind of this incredible levels of kind of being overworked. It's the same in delinquency court, where you have attorneys meeting juveniles right before their hearing and talking to them for just a few minutes, talking to them, you should probably plea, here's what you should do. Because the attorneys are under kind of tremendous pressure to get to the next case, to get through this one. And so it may be a combination of those types of factors, more so than an inability of children on the part to really understand anything.
Mm-hmm. Do you have any resources that can help providers working with justice impacted youth to better understand the terms and basic court procedures, with an understanding that they're different based on the state, county, et cetera, so that we can better serve our youth and encourage them to ask appropriate questions when in court?
So right now, there aren't great resources in the United States. Ironically, Canada, which, and some facets of their justice system are the same. Canada actually does have a better model for kind of teaching children. They actually have these kind of court schools for children. They've adapted different ones for children and adolescents. And so when sometimes we have children involved as witnesses in cases, we'll actually pull up some of the Canadian online. It's the Canadian, I can get you the name. It's like the Canadian Association for the Protection of Child Abuse Victims. Those are the ones that we've really seen that are really well done, well structured. I have not seen them in the United States, but I assume that probably each state and counties have different simplified versions. And so one of the things that I would always caution people is don't just give children a pamphlet. Don't just give them a storybook. Talk it through with them, ask them questions about it. So just giving kids a flyer, giving them a handbook, giving them like a pamphlet, they're not going to read it. You won't know if they understand it. Whereas in contrast, if you give children something, but you go through it with them, you can track and you can assess, here's what they know, here's what they don't. Let's talk a little more about this. And that probably would be the best way to use individual county materials and individual state materials in an effective way.
So a youth who feels he or she hasn't really been afforded due process due to lack of comprehension could file to suggest ineffective assistance of counsel, as it's the attorney's responsibility to ensure a youth understands. That's why attorneys request that forensic psychologists conduct, aid, and assist evaluations of youth to ensure that understanding. So that's just a comment, I think, on one of the questions from earlier.
Okay, no, so thank you. So yes, it's a tricky thing because you have the judge's oversight, but the attorney is supposed to be going through the document that youth sign, but you have sort of these other people who should be involved. And I think, I think involvement of forensic psychologists would be fantastic. I think attorneys are overworked and burdened. But in a lot of the cases that we see going through, particularly our delinquency branch, they're fast. And youth are sort of showing up, they meet their attorney, and they walk in right into that initial hearing. And so unless you really have kind of a forensic psychologist right there holding things up, I'm not sure logistically that would work in the current structure, but I think it's incredibly valuable to kind of think about whether there's ways you can sort of implement these stopgaps in the future.
So everyone that's on, we are right at the hour. So if you need to jump off, now is the time. We are going to stay on for a little bit longer and answer questions. That survey link has been posted in the chat. So hopefully it's working for everybody this week. Sorry about last week, by the way. Someone put a comment that AFCC has great trainings to help providers, attorneys, guardian ad litems, and other professionals to assist professionals in understanding children in the legal system. So that may be another good resource for people. Another comment, ineffective assistance of counsel arguments rarely succeed except in flamboyantly incompetent cases. These arguments have failed even when attorneys have been visibly intoxicated or even asleep.
So yeah, I think it's also a lot harder in juvenile cases because there's just less documentation.
Yeah. Next person says they're interested in capacity evaluations when working with younger kids. When you studied and researched capacity, was it with the 4 elements of capacity in mind? So ability to make a choice, ability to understand relevant information, ability to appreciate the situation and the consequences, and ability to manipulate information. They're interested in how these discussions occurred with young kids. For example, were the youth able to appreciate a situation such as discussing how returning home with kin or being in a different environment may impact them? They want to know how these discussions happened and what your studies found.
That's a great question. And this idea of sort of capacity. In our studies, in our studies, particular studies of placement, we were not focused on kind of these broader capacities of children. They were really these very simple, very straightforward, yes, no questions or questions about where they want to live. So we weren't looking at those. I think if I was going to make recommendations to social workers, attorneys, guardian ad litem, judges about engaging children in conversations, I think that questions that really ask them, tell me about what you like about being home, tell me about what you like about this placement, those open-ended questions where you're getting information from children about why they might be leaning towards one place or another could be incredibly valuable. Not thinking of them in terms of these 4 capacities per se, but really trying to gather all that information to understand what's motivating their decisions. So we didn't do that, but I think that's a really important piece. In terms of our study of just children's general kind of understanding of the dependency system, we didn't frame it in terms of these different capacities, but certainly some of our questions were trying to tap into those, because we were asking, you know, what's the purpose of, okay, so a child meets with a social worker. Why is, you know, what can the social worker do? Tell me more about what the social worker does. So those types of questions, I think, will begin to tap a little bit of this capacity to understand in these broader domains. But I think your open-ended questions, tapping into those, if you ask open-ended questions, if you pause and if you sort of work with children, not always, but oftentimes you can gather really important and valuable information from them that is directly relevant and then can help you assess their capacity, help you assess what they're thinking about, help you assess what their needs are in a way that's really building on what they're telling you.
Anybody else have any questions? I'm going to give it just a minute. Okay. Well, thank you so much for your time today. This was amazing. I wish we had a lot more juvenile talks to come by. But I really appreciate your time today. Thank you so much. And thank you everybody that joined us today, and we will see you all next week.
All right. Thank you so much, everyone.
Take care.